Legal dictation exercise 98 start. In the present case, the respondents in the writ petition had raised a specific plea on delay as a bar to grant relief to the petitioners. Full stop. In our view, it was perhaps necessary for the court to have specifically dealt with this issue. Full stop. It is now well settled that a person who seeks the intervention of the High Court under Article 226, should give a satisfactory explanation of his failure to assert his claim at an earlier date. Full stop. The excuse for procrastination should find a place in the petition filed before the court, and the facts relied upon by him should be set out clearly in the body of the petition. Full stop. An excuse that he was agitating his claims before authorities by making repeated representations would not be satisfactory explanation for condoning in the inordinate delay in approaching the court. Full stop. If a litigant runs after a remedy not provided in the statute, it cannot be a satisfactory explanation for condoning the delay in approaching the court. Full stop. Para. On this issue, we have heard the learned counsel for the parties in great detail, since the immovable property rights of the parties are involved. Full stop. In our considered view, there is no explanation, much less satisfactory explanation offered by the respondents in approaching the writ petition and court after an inordinate delay of nearly 15 years from the date of the notification issued under the Evacuee Property Act. Full stop. For the delay from 1952 to 1955, the contesting respondents would only submit that they were not aware of the notification issued under the Evacuee Property Act, since no notice was served on them, though a public notice was issued by the authority under the Evacuee Property Act. Full stop. While explaining the delay of nearly 11 years from 1955 to 1966, they contend that they were in possession of the property and they were making representations before the authorities under the Evacuee Property Act and redressal of their grievance. Full stop. The delay after the orders were passed by the Settlement Commissioner in the year 1983 till the writ petition was filed in the year 1990, it is explained that they had moved the state government so moto to revise the order passed by the Chief Settlement Commissioner, and since the state government returned their request, they had approached the High Court to issue directions to the state government to issue appropriate directions. Full stop. Para. In our considered view, there was inordinate delay in approaching the authorities for redressal of their grievance, full stop, as rightly contended by Sri Mukund, even when they approached the authorities, they were claiming wrong reliefs or incomplete reliefs, full stop. Even when they filed the writ petition in the year 1990, they did not choose to question to correctness of the notification but the question by way of filing an amendment application in the year 1998, full stop. There is some merit in the submission made by learned counsel for the contesting respondent that the respondent petitioners had not even offered any satisfactory explanation in approaching the court nearly after 3 decades from the date of notifications issued under the Evacuee Property Act, full stop, para. It is now well settled that the power of the High Court under Article 226 of the Constitution to issue an appropriate writ, order or direction is discretionary, full stop. One of the grounds to refuse relief by a writ court is that the petitioner is guilty of delay and laches, full stop. Inordinate and unexplained delay in approaching the court in a writ is indeed an adequate ground for refusing to exercise discretion in favor of the petitioners therein, full stop. The unexplained delay on the part of the petitioner in approaching the High Court for redressal of their grievances under Article 226 of the Constitution was sufficient to justify rejection of the petition, full stop. The other factor the High Court should have taken into consideration that during the period of delay, interest has accrued in favor of the third party and the condonation of unexplained delay would affect the rights of their parties, full stop.